with the authority of the public official comes a responsibility. The oath that the public official takes creates a fiduciary obligation of that public official with the constituents, the public. It's the same fiduciary duty that the CEO of a publicly held company has to its stockholders. It's the same fiduciary duty that I have to the Department of Justice. It's the same duty that you have by virtue of a responsibility and a relationship. Normally, in an arm's length transaction, you don't have to tell people material facts. You can't misrepresent them, but you don't have to speak material facts. Not so when you have a fiduciary duty that's established between the public official and the public. And that comes just by virtue of the oath. So, how can a public official defraud the public? By concealing a financial interest in a matter before them, by concealing a financial relationship with a party before them. And if the official sits silently, they have an obligation to speak and disclose. It's a fiduciary duty that causes that person to have to speak up and disclose those relationships. So, if you stay silent, what is that evidence? That is evidence of an intent to deceive. Okay? So I still have to prove, and still must prove, an intent to defraud, and that proof comes from silence in a situation where you have the affirmative duty to speak. So, if there was a matter that came before you as a public official in which you had a concealed financial, these are the easy ones, a concealed financial interest in that matter and said nothing, then there is proof at that point in time that you intended to deceive the public with respect to your relationship with that matter that was before you. Obviously, the policy behind all of those requirements of the law is that the public must have the confidence that the officials making judgments are making them based on what's best for the public as opposed to what's best for them personally.